letters, I want to kind of go through it real short and quick, so the attorney doesn't have to listen to it very long.
Okay.
And then when I'm done talking, you can keep recording, and then you can ask me questions and stuff. If the attorney doesn't want to listen to the rest of it, because for sake of time, he doesn't have to.
All right, we're ready to go. So you go whenever you're ready, sir.
Okay. This is in association with the motion that I hope that various attorneys are working together to have count. I think it's number 5 dismissed, which is associated with contempt of court for clouding a title or attempting to cloud a title. The first thing I wanted to bring out is that when the attorney noticed me that I was not to send any mailings or any acts that would cloud the title or attempt to cloud the title without first notifying, having permission by the court or working through an attorney, that in that notice, the court officer, an attorney of the court, told me that that if I did do something like that, I could be charged with civil contempt, civil criminal contempt. Civil contempt. Okay, so I took that to a friend, and he said, well, that means no jail time. That just means, you'd be liable for damages in a civil court. So, and then all of a sudden, I get arrested by a SWAT team, and I'm charged with criminal contempt. A whole lot different. So I think that's very important that the court officer told me that it was civil contempt, and then it ends up being a criminal contempt. Completely much serious issue when it's done. But first of all, I wanted to say that the lien, the $1 million lien, Glenn Stoll in Washington state created the lien for $1 million, so I had nothing to do with that. And 3 of the 4 trustees decided that they wanted to send this lien, and I was the only trustee that didn't want to participate in that, and I testified to that. And they felt that it was their duty to defend the trust, and they didn't believe that it was a violation of any law or anything like that. And I suppose they noticed the letter, the same letter I had, that said civil contempt, and they were certainly willing to, if they damage anybody, they pay a little bit of civil damages if it delayed a sale or something like that, which there's no reason why it would have. But anyway, the main thing is that the trustees thought it was their duty, and I couldn't overrule their ruling, so they went ahead and mailed the document to the court clerk. And then on that document, I never did sign it. My name was cut and pasted and placed on that document. So I never actually signed it. I did tell them that, I agree that we still have a legal interest in that property, but I didn't want to participate in anything that could even touch that civil contempt. I just didn't have to, so I just wanted to stay out of it. And I didn't need to get involved. They could do anything they wanted without me. Okay. Another thing is that when that lien was mailed to the court clerk, where it acts like a register of deeds, register of liens, it was rejected because it was $1 short on filing. So it never did get filed. Wow. And then also when it didn't get filed, the clerk mailed it back to me because Glenn put my return address on the filed documents. I don't know why he did that, but anyway, it was mailed back to me in Nebraska instead of to him in Washington. And then the next thing is when I received that letter that was rejected by the court clerk, register of deeds in a sense, the trustees wanted me to, since it was rejected, just go ahead and mail a copy of it to the attorney of the title companies, just to give them, we thought it was prudent to give them notice, and a good neighbor would give them notice. So I did that. And then the attorney testified in court that he considered it a direct notice of a lien, and then he said it was a cloud on the title. He considered it a cloud on the title. Now, in cross-examination of that same attorney, he was asked if he sent any email, any phone call, any mailing at all that had language of it that there was a proof of any delay or any clouding associated with that document. He had no such evidence. So there he sits in the witness chair and he says it clouded the title, but there's no evidence in any communication in his office to any of his clients that we have a document here that's clouding the title. And there's no evidence of any activity of paperwork or going to the courts or anything, or going to the clerk's office or notifying his attorney or notifying us of lifting any cloud.
Right.
No issue of lifting any cloud. If there was a cloud on the title, how did it get lifted?
Right. Amen. Good point.
It'd still be there. It'd still be there.
Good point.
Now the United States says that they went ahead and indemnified the sale of the property. I think that's the word, but basically the word, I can't remember if this is the exact right word, but the United States, they said they would guarantee the title. So if there was a cloud on a title, they said they would cover any of those issues of the title. So now there's never been any evidence that there's a cloud on the title. Nobody's ever notified us, hey, get down here and clear this thing. We've never received a letter or anything that lien was lifted.
Right.
Now the other liens that we had on before, they sent us a letter and said that those liens were considered null and void. We've never received anything about this thing from any title company or anything. So basically, to get this charge dismissed, I did not file or attempt to cloud. It was only a prudent notice in common law, independent of any United States office. We never mailed anything into an office that operates on land of the United States or for the United States. The jury never gave findings if I was found guilty for being associated with the lien going to the court clerk that Glenn Stoll mailed for the attempted filing that was rejected for the $1 being short. So the jury never gave a finding that I was associated with that. Nor did they give a finding that my mailing to the title company attorney is why I've been found guilty. I don't even know what I've been found guilty of.
Right.
All I know is I've been found guilty of count 5, but nobody's told me what I did. So how in the world do you appeal that? How do you challenge that? So I think that's an important issue to look at. And the one last thing, none of the acts were done on U.S. land. None of the mailings, none of the letters went into a United States territory. So I believe it's a territorial jurisdiction issue. All of these issues should have been brought to a common law court, not to the United States administrative court. And because the United States courts are limited, they're limited jurisdiction courts. They have to prove territorial jurisdiction, and they failed to do that even when I required it of them during the process of the paperwork. So I just wanted to any attorney that's working on this to consider these factors, and it might motivate them to, it might spark some of their mindset on putting the proper argument together to have that case, that charge count 5 dismissed. Now, if we get count 5 dismissed, then there's no reason for them. That would dismiss all the charges. Therefore, they had no reason to require me to fly to Florida and give fingerprints. So I believe that would also end up causing count 6 to be dismissed also. So, okay, any questions?
Yeah, Paul, I do have questions. Count 5 was the criminal contempt of court. That I understand you spoke to a bar licensed attorney, and he said the worst that he expected to come out of that was civil, right? And you said that they changed it and now it became criminal. And that can involve jail time. But your understanding after you spoke to a bar licensed attorney was that it was civil only. So the worst that could happen is there would definitely be no jail time in your mind, right?
Yeah, you're talking very loud.
Oh, sorry.
Anyway, yeah, the document that they mailed me to give me notice that I was not to do anything to cloud the title, or even attempt to do it without getting the court's permission or working through an attorney, licensed attorney. So one of their attorneys mailed me a letter and said civil contempt in it.
Okay.
And then when I got the letter, I took it to an attorney at church, and I just said, I never heard of civil contempt. What is that? And he says, well, that just simply means that there's no possible jail time for it.
Gotcha.
That you would just be liable for maybe paying for some damages that would be created by an activity that the court's telling you not to do. I go, oh, okay, well, that's a whole lot better than going to jail over something.
Right. Okay.
So I would have conducted my entire activity differently if I would have been informed properly by an officer of the court.
Right.
So he misinformed me.
Okay. Gotcha. Okay. So I guess a question I would have, Paul, the letter that they sent you, when I say they, I guess it would be I don't know who, it would be the prosecuting team, right? Or maybe some representation from Judge Margaret Casey Rogers. But do you have a copy of that letter somewhere that says civil? That said civil contempt of court? Is that in a letter that we can actually scan and put up for people to look at?
I think I could find it. It might take me a while, but
okay.
Yeah, I can find it. But
okay.
It was one of the exhibits that they put in.
Okay.
It was basically the court order told the court clerk to have a letter assembled that would give me notice, and they mailed that to me by certified mail. So I got that letter. And it was written by one of their attorneys.
Okay, it may be in pacer.gov. Maybe if it was an exhibit.
Oh yeah, it'll be in there. Yeah.
Okay, all right. Okay.
Yeah.
Now,
and Ernie probably has it.
Okay. So. Okay. Very, very good. Very good. So count 5 was contempt of court, and you said if count 5 gets dismissed, that could also possibly cause count 6 to get dismissed. Can you remind me of what count 6 was? I forget myself.
They subpoenaed me to fly from Nebraska to Florida for fingerprints and handwriting exemplatures. Now they never did take any handwriting exemplatures, but I wrote them back, and I told them, I said, there's no language on the subpoena that infers that there's a legal duty there. There's no language that refers to a written law. And I wrote him a letter. I said, well, what written law are you referring to that places a legal duty on me to take my time off and fly to Florida to give hand fingerprints, especially when I can walk 2 blocks to the federal courthouse here and give my fingerprints, and also that they've got at least 10 sets of my fingerprints already.
Right.
10 different sets. I've been, they've harassed me for years. They got 10 different, every time you're booked, you get your fingerprints taken.
Right.
They got all kinds of fingerprints from me.
Right. Okay.
So simply, I just asked them, I said, give me the law so that I can clearly see that I've been noticed of my duty. And if there is no law, then I told them, I said, well, you guys got to pay me $150 an hour for my time to fly down to Florida until I get back.
Right.
I wasn't going to fly down there because of some invitation.
Right. Amen. So it was basically they're saying that you ignored a subpoena. Do you remember the exact wording of count 6? I mean, I'm trying to remember because I at one time I remembered what all the counts were. It was
count 6 is the same charge as count 5. They're both criminal contempt.
Gotcha. Okay, they're both criminal contempt of court. Okay.
Yeah.
Okay, so count 5 is criminal contempt of court for the alleged clouding of a title, and count 6 is criminal contempt of court for ignoring a subpoena, I guess.
Yes.
Okay.
Now, for example, if they would send me the written law, and I would go to the statutes at large, and I would see exactly what the legislature said that law says, and who it. See, the statutes at large has to notify you of the type of person that the law applies to, the type of activity, and the location where the law is operative. So that I could examine that promulgation of that law to see if it applies to me, because it might say in that law, in statutes at large, upon U.S. citizens.
Right.
Upon U.S. citizens. So I would write them back. I said, do you have any evidence that I've elected to become a U.S. citizen? Because there's only one way to become a U.S. citizen in America, in the United States system. You have to stand before an officer of the United States, you have to be sworn in, and you have to take an oath.
Right.
If you haven't done that, you're not a U.S. citizen.
Okay.
You just think you are.
Yeah.
Now, you might be contracted with the government by filling out tax forms and so forth, or various documents, but you're not legally, by written law, a U.S. citizen.
Okay.
They don't want nobody to know that. They don't want nobody to know that. And they tried very, very hard to get Ken Hovind or I to say that we're U.S. citizens in the courtroom.
Mm.
They tried to be very slick about it.
Yeah.
They wanted us to say either we're a U.S. citizen or we're a resident in the United States.
Okay.
It's both mean the same thing.
Gotcha. At some point.
No. The residency is a contractual issue. Contractual. If you're a resident, you're standing in their jurisdiction, and they can serve a subpoena on you with a lot less standards than if you're not if you're not standing on their land.
Yeah.
See, if you're standing on their land, they don't have to have extradition.
Yeah. Gotcha.
If you are standing on their land, they do not have to have extradition. If you are not standing on their land, they're supposed to come to that jurisdiction and get extradition.
Yeah.
They have to prove in a court of record that they have probable cause to cause you to appear somewhere.
Yeah. No, it makes complete sense to me, Paul. I might have some questions for you at some point regarding the term natural born citizen, and how for those that would say we get citizenship by our birth. But before I get into that, and that may be a topic for another video, I want to be clear on this criminal contempt of court in count 5. Are you able to hear me okay, or am I speaking too loud still, or?
Still too loud, yeah.
Okay, I'll try to speak a little lower. The Liz pendants that everybody normally associates with this case, you're not involved with the mailing of the Liz pendants. That's not you, right? That supposedly came from Ken Hovind.
That's correct. The jury actually found that me not guilty of any association with Liz pendants.
Okay.
So that is completely out of the picture.
Okay.
Because they found unanimously that I had nothing to do with Liz pendants.
Okay. So people need to get Liz pendants out of their mind when they think of Paul Hansen, because you're not in any way associated with that. What they're claiming that you did is you mailed a lien. They are claiming that you mailed a lien, and it clouded the title of a property that the government illegally seized from Ken Hovind's ministry, the CSC ministry. And what you're saying is you weren't even involved in the decision to mail that letter, and that your name was put on there cut and paste, and that Glenn Stoll put you as the return address, and out of all the trustees that signed it, they decided to go after you and only you. And what you're claiming is that you didn't. It didn't even cloud the title to begin with. Am I getting the picture straight?
No.
No. Okay. Yeah. I'm sorry.
It didn't even cloud the title.
It did not even cloud the title. Right.
Now, I would be interesting to find out if I could be charged with contempt of court for attempting to do something.
Yeah.
For attempting. See, there's no evidence that I was even attempted to cloud the title, because if I was successful in mailing this letter to the attorney, which I was, I was successful. It didn't cloud the title.
Right.
He said it clouded the title, but there's no evidence that it clouded the title.
Right.
If it clouded the title, that would have mean there would have been a delay in sale. that a process would have had to been done to lift the cloud.
Yeah, they didn't have to do anything to get rid of the cloud. I mean, if it clouded the title, they would have had to do something to get rid of it. But you're saying nothing was done to get rid of the cloud, so therefore it wasn't clouded to begin with.
The only man that's ever communicated that it clouded the title is the attorney in the witness stand was asked, "Did it cloud the title?" And he goes, "Yes." And I think he was coached to say that.
Wow.
Because he didn't have any evidence
Yeah.
that it clouded the title.
Gotcha. Okay.
After that, we should have got on that a lot heavier.
Yeah.
If I was cross-examining him, I would have said, "Were you coached to say this?"
Yeah. Yeah. Amen. Amen.
I think the jury actually seen it in the reflection of his voice and stuff, and the demeanor of his face.
Yeah.
I think they could actually see that he was making this up.
Okay. So let me take a step back, Paula, to the 30,000-foot view. You're coming upon a sentencing hearing on June the 29th, and what are you hoping to accomplish by making this video? What are you hoping to accomplish with telling this story? Because from the judge's perspective, and I got my own thoughts about this judge, and some of it's not good to say in a public video because I think she's so biased and she's so evil in her biasness against you and Mr. Hovind. But my question is, what are you hoping will happen on June the 29th? Do you have people that are coming in to testify on your character? Do you think that some of this information will play into your sentencing with the judge? What are you hoping to be accomplished?
No, I don't think anything we're doing here is going to play into the sentencing. My motivation is to get a little bit of communication to those attorneys that are working on the brief to assemble a motion to dismiss count 5. But as far as the sentencing date on the 29th at 1 o'clock, that I'm trying to get 2 people to fly down that have known me for at least 4 or 5 years in Omaha. Ideally, my pastor and the head elder of the church, who I both spent much time with them, and so basically to get people to, and then we got letters being emailed in by 15 people. Now we don't want anybody to mail in letters to them unless I've told them to, because we don't want a flood of letters, because the flood of letters just simply means the judge is not going to read the ones that we actually want her to read. We want her to read the ones that that people actually know me quite well and things like that. Right. But the main thing that I want to express on the record to the sentencing judge is that every action I've ever done is to try to restore the property to the church, not to me. I've never been paid a dime for this.
Yeah,
to the church,
right.
Or at least have our day in court, so that we can get this thing settled. We've never had our day in court. They just took it away from us. And also that I in all aspects of government or our lives, I want to return to what our founding fathers inspired, as far as a limited federal government, a strong local community. This whole thing should be settled in the community court, not in a federal court. And basically, that's my goal, to get our day in court in a local court that's a lot more reasonable. Yeah.
Hey, Paul, you just said something that was incredibly profound, and I wanted to bring it up again in case anybody missed it. Because I'm probably going to put this on YouTube, but I want to make sure that everybody understands what you just said. You're in prison right now, looking at some serious possible time with this particular judge, not because of anything you were doing to protect your own property. You got involved to help Ken Hovind, right? You got involved to help Ken Hovind, and you didn't even get paid for it, and you just did it because you saw an injustice, and you wanted to help Ken Hovind's ministry, and you were trying to protect property from a government that illegally seized the property, but you weren't personally getting anything out of this. You just trying to help a brother out, and now you're looking at prison time because you just simply wanted to help out. You weren't even getting paid.
Yeah, they're trying to give me, at the minimum, 5.3 years.
Wow.
Or 5.25 years.
Wow. And you weren't even getting paid for anything you were doing. You were just trying to volunteer to help out Ken Hovind's ministry.
Yeah, because Kent clearly communicated to him that nobody wants to help.
Wow. That is. Hey, Paul, we're praying for you, brother. It's insane what you're going through. It is absolutely insane. I pray you get out of prison, and I wish the country had more men like you. And we got to turn this thing around, because some very corrupt people are in power right now. And the fact that you've spent in jail since October of last year is just a terrible, terrible travesty, brother.
Yeah, there should have been 100,000 people.
Yeah.
In front of that courthouse,
Yeah,
to show the horrible injustice of this whole thing. Because the whole thing is based on Scott Snyder made a false claim that Kent had a duty to withhold money from 40 workers at a church ministry.
right.
He's never had that duty in any way at all.
Amen.
He probably didn't even have authorization from the government to collect those taxes.
Right.
And the attorney that Kent paid $110,000 to was told to challenge the to ask Scott Snyder in the witness stand what he relied upon that Kent had a duty to withhold taxes from those workers, and that paid attorney didn't do a single thing to defend Kent.
Yeah.
He would not ask that question because he feared, I'm sure this is why he didn't do it, just like every attorney I've ever talked to in the last 20 years has told me, you cannot beat the IRS. They will destroy you.
Yeah.
They will destroy you. Why would I want to spend the rest of my life fighting the IRS when all I have to do is stand up to the court and say, no defense, Your Honor?
Yeah. Right. And that's Alan Stewart Ritchie specifically. That was the attorney that Ken had nearly 8.5 years ago.
Yep, and I told him, I spoke on the phone with him directly, and I told him the defenses.
Yeah.
That he should, the simple defenses. All he had to do was put Scott Snyder in a witness chair and ask him, do you believe that Kent had a duty to withhold those taxes? He'll say, if Scott said yes, what do you rely upon that created that duty upon Scott?
He can't answer.
Upon Kent.
Yeah.
He would not have an answer.
He wouldn't have an answer, right. Right. So this
Kent
yeah.
would have not gone to jail.
Right.
With that simple question.
Right. Right. This whole thing is built on just absolute cards, and it's there's other agendas going on, and we're praying that you get out soon. I think we are going to have a few folks that are friendly going to be in your sentencing hearing to make sure that everything is taking notes, and they'll write down what's stated to the best of their ability anyway. We're coming up only a minute and 40 seconds. I'll put more money on the account, Paul, and you're always welcome to call back. But
Okay.
we're hoping that Ken gets out soon, and we'll continue efforts to get you out of there, Paul. It's absolutely just terrible that you're spending all this time in prison, and I pray that you get out very soon.
Now, I just found out a few minutes ago that Kent notified somebody and that he's actually being tortured.
Yeah.
In Mississippi, they're trying to basically kill him with. That's what the letter looks like.
Yeah.
They're actually trying to give this guy pneumonia. They're trying to freeze him to death in his cell. They took most of his clothes away from him.
Yeah.
He may not even have a blanket. All he's got is a T-shirt and his underwear. And he's got to stand in the shower. There's a shower. Happened to be a shower in that little cell. He's got to stand in that shower and let that little sprinkling warm water run in the shower to get his body temperature.
Yeah. Yeah.
Ken actually wrote, they're trying to kill me.
But he wrote down out there, I'm freezing to death. Yeah, I'm freezing to death.
Freezing to death.
Yeah.
So, okay.
Yeah, it's
Anyway.
We're gonna pray for you, brother. We're gonna do everything we can do, and we're never gonna let go, and we're gonna keep screaming until somebody pays attention. I know God sees everything that's happening, brother. So.
Yeah, we need 10,000 people calling that prison tomorrow.
Amen.
So they can stop this.
Amen. Amen. We sure do. We sure do. God bless you.
I got 10 seconds left. Right. I'll let you go.
God bless you, Paul. Call here anytime. I'm going to put more money on the account. We lost him. I lost you, Paul.